The Supreme Court made a surprise announcement yesterday that they would be releasing a decision today, and they did. Help us understand the decision and what it means for abortion in Texas and America is my colleague, FRC's Research Fellow for Legal and Policy Studies, Katherine Johnson. Katherine, welcome back to the show.
Thanks for having me, Joseph. It's great to be back on with you.
Well, we're glad to have you. There's some good news here in that there's a lot of activity for pro-lifers to be keeping track of. The bad news is it's easy to be confused by all of us. If you could start off by reminding us what the Texas heartbeat bill was and why it was at the Supreme Court.
That's exactly right. It can be certainly confusing. It's a nuanced opinion, a nuanced case. So Texas passed a heartbeat ban, banning abortion after a heartbeat can be detected, which is around 6 weeks. Because this would be unconstitutional under Roe and Casey precedent for the state to enforce that law, the authors of the bill were very creative and came up with a mechanism where the state was actually not permitted to enforce the law. Instead, it would be private individuals enforcing this law. So, for instance, if I was aware that an abortionist was committing an abortion past 6 weeks of pregnancy, I could sue that abortionist for $10,000. Now, because this is enforced by private individuals, there really was nobody for the abortionist to sue to stop this law from going into effect. So it's more of a procedural way around Roe and Casey. It was a brilliant and so far pretty successful attempt to save lives in Texas. And that's what this law is, which is separate from the Dobbs case that you just mentioned, which has the potential to undo Roe and Casey and actually have states go in and enforce abortion bans.
Now, we know that the Supreme Court had previously declined to jump in and stop the Texas heartbeat bill from going into effect. I know there's a lot of procedural kind of legalese in this particular decision. Bottom line it for us, if you could. Are abortions legal now in Texas or not?
The bottom line is this law is still in effect. So as of now, lives are still being saved. I believe there's already been over 15,000 lives saved in Texas. So yep, as of now, the Texas heartbeat ban is still in effect, which is a huge win for us.
That is tremendous news, and we continue to just be thankful that the changes in the Supreme Court over the last several years, first when they jumped in and refused to intervene to stop the Texas heartbeat bill from going into effect, and now on really a procedural, there's a lot of nuance here, but they have again followed the law and said this is going to stay in effect. Litigation will continue, but the fact that the Supreme Court is not taking every opportunity to support and defend abortion is itself a step in the right direction, isn't it?
It is. And I really think it's going to be difficult in the Dobbs opinion, which will hopefully undo Roe and Casey, overturn them, say that abortion is not a constitutional right. I think that this is promising for that case because it'll be hard for the court to come down with this opinion as they did today, saying that's fine that abortion is essentially banned in Texas. And then in a few months saying that abortion is an incredibly important constitutional right that's just bedrock in our jurisprudence as a nation. So I think that this is really promising that the Supreme Court recognizes that abortion is no longer this super right, as Justice Scalia and Justice Thomas have talked about that for so long, for 50 years almost, has really gotten special treatment in the courts and in our jurisprudence. So like you said, it's really encouraging now that we have justices that see there are other rights at stake and other interests in our legal system.
And we're talking to Katherine Johnson. Katherine, this case, the case that the Supreme Court just released a decision on this morning was really the abortion industry's attempt to throw the kitchen sink, proverbially, at this heartbeat law and make it stop. It was unique, and you've mentioned that. But my understanding is this doesn't necessarily stop the litigation against the heartbeat bill. It will remain in court. Is that right?
That's right. There were a lot of different split opinions in this opinion that came out today. Justice Thomas would have stopped this case immediately and would not have had it permitted to move forward at all. There were 8 justices, however. Every other justice agreed that this suit could go forward against licensing officials in the state. And then the liberal justices, along with Justice Roberts, who has started voting lockstep with the liberals, would have permitted the state judge, the state clerks to also be enjoined from this. So really what that means is only state licensing officials are the ones permitted to be sued by abortion providers. All of the justices agreed that the private individual named was not permitted to move forward. And really, this is a win for pro-lifers because first and foremost, it's pretty clear that the Texas lawmakers could rewrite this simply to remove any authority of licensing officials to have over SB8, the heartbeat ban. And secondly, the court has said that they will defer to state officials to interpret their own state's laws. So Texas could come up and say, look, we don't think that these licensing officials actually have the authority to enforce SB8 or to be involved in this at all, in which case that would remove the suits going forward of the licensing officials, which the Supreme Court held today is the only officials that the suit can move forward. So it's definitely something that will be interesting to follow. It's not the end of litigation in this case, but it still was a huge victory for pro-lifers.
Now, you mentioned all of the defendants in this case, court clerks, licensing officials, even judges who were named as defendants. We don't typically see judges as defendants in cases. Why is it that court clerks and judges ended up being named defendants in this suit?
The pro-aborts wanted to stop these cases from going to court. So they wanted to say a private individual can't bring this $10,000 suit in court. Therefore, state judges and clerks cannot hear any case pertaining to this topic. And that really would have been an incredibly aggressive move. That would have been unheard of, unprecedented for the Supreme Court to prevent state judges from hearing any case pertaining to what this law permitted, which happened to be an abortion case. But it really would have been unprecedented for the Supreme Court to come in and stop state judges from hearing a case that pertained to any issue.
So it isn't really a radical step of a conservative court to defend the pro-life position. It really is just a defense of the justice system as we have been operating for a long time. Is that true?
That's exactly right. Because the case deals with abortion, the left is painting this as just radical hacks on the Supreme Court. But really what we have are justices who are smart, who have deliberated, and who recognize that abortion is done getting a pass in our court system. And that just makes the left very upset because abortion is their most cherished right that should get any pass that they deem worthy, which happens to be every pass.
And to that point, if we are now doing a better job of evaluating these cases on the merits rather than with consideration to the underlying political issue, what do you think the future is for the Texas heartbeat bill?
I think that it definitely depends what happens in Dobbs. What is best case scenario is that in Dobbs, Roe and Casey are overturned and states have the authority to go in and outlaw abortion starting at conception. And with that, the state would have the authority to press criminal charges to the abortionists, to those who help. I don't think any state plans to criminalize women at all. This would very much be targeted towards the abortionist. And that is stronger than relying on individuals to have a $10,000 fine. And so what happened in Texas was very much a result of being bound by Roe and Casey, and it was a brilliant workaround. But best case scenario is that Dobbs overturns Roe and Casey, and the state has the authority to ban abortion at conception.
I've heard some concerns about the Texas heartbeat bill and the idea that the same mechanism of allowing individuals to sue to enforce a law could be used by the left to, for example, sue people for violation of, or for gun rights violations or things like that. Do you think that there's any concern about this mechanism used in the Texas heartbeat bill being used by the left on issues that the right might care about?
I don't, because first we need to be aware that the left already is going after the rights. And I think that this is very clear, like in Masterpiece Cake Shop and other instances, the left has written laws that infringe on our religious liberty and everything else. So the left certainly does not feel bound to play by any neutral standards. And I also think that there is very much a difference between a written First Amendment right, such as to free speech, and a court-made right of the so-called right to an abortion. The courts might view them similarly, but they also might not when it comes to this mechanism. So we'll have to stay tuned to see what happens if the left does go after a fundamental written First Amendment right or Second Amendment right.
So, Katherine, I think it's the last question. Your general sentiment about how this is all going to shake out. We got Dobbs, we got the heartbeat, litigation. What's the timeline? What's the end result of all this going to be?
I think it's incredibly hopeful for the pro-life movement. We've picked up steam. We have good justices. And like I said earlier, 15,000 lives have been saved in Texas, and we look forward to that number only increasing across the nation.
Well, we are encouraged by your optimism. We share it, and we will be in prayer. Katherine Johnson, thanks so much for your time.
Thanks for having me.